I was at Nagpur, and Justice Bobde was also there. So we had started a study circle wherein every fortnight there used to be lectures, and everybody, including the lawyers, they used to interact with everybody, and so it helped us enrich our knowledge of law. So therefore, I am sure that this initiative by the Supreme Court Bar Association will help everyone, and specifically the young members of the bar, because we always say that in the legal profession, the learning is a continuous process. So even as judges, we are still in the process of learning every day, and I'm sure that this exercise will certainly help all the members of the bar, and particularly the young members of the bar. The SCBA has long been a pillar for the betterment of lawyers practicing before the Supreme Court, advocating for their professional development, ethical standards and welfare. Every week I get some mandamus from Mr. Vikas Singh, and today also I received a mandamus in the morning that you you ask the gate number 1 to be opened at least 2 hours before the function, and I can't afford to deny his mandamus. Every year we have been, every week, either Pragnya or Rahul, somebody is there in the chamber in the lunch recess with some suggestions and concerns concerning the member of the bar. There are various issues regarding the professional practice, such as case listing, infrastructure, and procedural reforms, and also the broader initiatives, including welfare initiatives, training programs, and measures to enhance access to justice. I must therefore congratulate the SCBA in being vigilant towards the issues faced by the members of the bar and bringing it to the notice of the concern. The consistent engagement of the SCBA demonstrated its active and constructive role in shaping the legal ecosystem, reflecting a commitment not merely to the interests of its members, but also to the promotion of efficiency, fairness, and excellence within the judiciary as a whole. Today's lecture marks a significant step in fostering dialogue, reflection, and collaboration between the bar and the bench. The theme of today's lecture, Justice for All, Legal Aid, and Mediation, the collaborative role of the bar and the bench, could not be more timely or more essential. Our Constitution enshrines the promise of justice for every citizen. Yet in practical terms, the path to justice can often be long, complex, and fraught with obstacles. For many, especially those from marginalized and vulnerable communities, the journey to a fair hearing is hindered by social, economic, and geographical barriers. Courts may be distant, proceedings intimidating, and access to competent legal representation limited. In such a context, justice risks remaining an abstract ideal rather than a lived reality. The collaborative role of the bar and the bench is a theme that bears emphasis. Lawyers are not just representatives of individual clients, they are custodians of justice, and they serve as the link between the citizens and the court. Judges, in turn, are entrusted with the solemn duty to ensure fairness, equity, and due process. When they operate in partnership, guided by principles of professionalism, integrity, and empathy, justice can reach even the remotest and undeserved corners of our country. I often say that judges and lawyers are like the two wheels of a golden chariot. Alone, neither can move forward with the same purpose or speed. It is only in their harmony, in their coordinated effort, the chariot of justice advances smoothly. Legal aid schemes have been a cornerstone of this collaborative effort. From the earliest days of our legal system, the recognition that justice must be accessible not only to those who can afford it has been central. Legal aid ensures that those who are economically disadvantaged or socially marginalized are not denied representation, guidance, or support in navigating the complexities of our legal system. However, many eligible citizens are unaware of their rights under their schemes. Here lies the role of both the bar and the bench to simplify, to guide, and to create an environment where justice is approachable, understandable, and equitable. Equally important is the role of mediation and alternative dispute resolution. In a country with rapidly expanding population and an ever-increasing caseload, traditional litigation alone cannot bear the burden. Mediation offers a path that is conciliatory rather than adversarial, restorative rather than punitive. It encourages parties to seek solutions collaboratively, preserving relationships, saving resources, and ensuring timeliness in dispute resolution. Yet its success depends on the good faith, expertise, and guidance of both lawyers and judges. In particular, I would encourage senior advocates to actively guide the parties appearing before them to consider settling their disputes through mediation. Their experience, credibility, and understanding of the law place them in a unique position to help parties appreciate the benefits of this approach, and not only in terms of time and cost saving, but also in preserving relationships and promoting mutually acceptable solutions. In contrast, both court litigation and arbitration often involve lengthy procedures, complex formalities, and significant financial expenditure. Lawyers who have achieved financial success and recognition in their profession also have a responsibility to devote a portion of their time to pro bono work, not merely as a charitable act, but as a matter of principle and professional practice. Their knowledge, skill, and experience should not remain confined to those who can afford legal services, but should reach every corner of our country, touching the lives of the most marginalized and vulnerable citizens. Thus, the legal aid and mediation together bridge the gap between constitutional theory and societal practice. Legal aid and mediation are instruments through which we translate the ideals of our Constitution into lived realities for the people. In this context, lectures such as today's are not merely academic exercises. They serve as catalysts for reflection, discussion, and reform. They remind us of our ethical responsibilities and constitutional duties, and the transformative potential of collaboration. They inspire young lawyers to see beyond the immediate advocacy and to recognize their role in shaping a fairer, more inclusive system. They remind judges that empathy, outreach, and accessibility are not optional virtues but essential components of judicial service. Let me also emphasize the symbolic importance of this lecture series. In a legal ecosystem often constrained by deadlines, filings, and procedural formalities, taking a pause to reflect collectively on the broader mission of justice is invaluable. It is in these moments of engagement between bench and bar, between thought and practice, that meaningful reforms begin. I am glad that SCBA has invited my senior colleague, Justice Surya, to deliver this lecture. Justice Surya has over the years consistently exemplified the constitutional vision. Through his judgments, writings, and engagements with both the legal fraternity and the citizenry, he has highlighted the importance of access to justice, the ethical responsibility of lawyers, and the need for the bench and bar to work in unison to reduce barriers of justice. As Executive Chairman NALSA, he has been spearheading the evolving policies on legal aid and alternative dispute resolutions. I hope that today's lecture inspires each of us to reflect on some fundamental questions. How can we, in our respective roles, ensure that justice is not only done, but is seen to be done? How can we leverage legal aid more effectively? How can mediation and alternative dispute resolution be integrated seamlessly into the mainstream without compromising fairness and accessibility? I am sure that with the rich experience of my learned brother, Justice Surya, the young lawyers, the students, and all the members would be enriched. I was told by Mr. Vikas Singh that the lecture series would be monthly, I'm really happy that all of us will get an opportunity to be enlightened on a variety of subjects by the judges of this court, by the retired judges of this court, and senior lawyers. I'm grateful to Mr. Vikas Singh, the office bearers, and everyone for giving me this opportunity to inaugurate the lecture series, which will be very, very valuable for all of us. Thank you very much.